वीडियो में जाने से पहले चैनल को सब्सक्राइब करना, वीडियो पसंद आए तो लाइक करना, कमेंट करना, शेयर करना।
Good morning and welcome. Today we'll learn about Article 32 and how it is linked to Supreme Court. It's been in news recently and therefore it becomes an important topic and we must learn about Article 32. So let's begin. What is Article 32 all about? Article 32 is mentioned in Fundamental Rights, which is Part 3 of our Constitution. It deals with right to constitutional remedies. If you feel like that your fundamental rights have been violated, you can straight away directly move to the Supreme Court and they will hear you. It's a right which is fundamental to all the fundamental rights guaranteed under the Constitution, and therefore Dr. B.R. Ambedkar correctly said this article is very soul of our Constitution and is very heart of it. Therefore, it's an important article. What does this article do? This article imposes a duty on the Supreme Court to issue writs in the case of violation of fundamental rights. If fundamental rights have been violated, you move to the Supreme Court. The Supreme Court will issue writs. Writs are nothing but an written order that orders given to someone to either stop doing it or compels it to do something. Supreme Court is the guarantor of our fundamental rights. There are few types of writs that the Supreme Court issues: habeas corpus, Mandamus, quo warranto, prohibition, and certiorari. Now let's learn about them one by one. Habeas corpus means to have a body. In layman terms, we can say that present the body in front of us. The Supreme Court will issue a writ and he will ask that you have arrested a person. The Supreme Court will ask the authority to present before them the person they have detained, also along with the reasons that why the person has been detained. And if Supreme Court finds that the reason provided by the authority, the detaining authority, aren't acceptable, or let's say they are very vague and not up to the mark to detain a person, the Supreme Court will say that set free the detained person and the person will be released. Therefore, this writ ensures that the liberty that is provided to us has been well protected. Now, principle of locus standi does not apply. So, like the Supreme Court asks the authority to present the person, and there is no right to be heard. They'll only ask that what are the reasons that you detained them, and they'll examine and they'll take the action. Against whom it can be issued? It can be issued against the state or an individual. State in the sense it means all the thing that are mentioned in Article 12, which says that state includes government, the Parliament of India, government and legislature of the states, all local and other authorities within the territory of India and in control of government of India. Now what's Mandamus? Mandamus is nothing but a positive command which the Supreme Court says to a public authority to perform his public duty to which it is bound under the law. Now principle of locus standi applies here, like you will be heard by the Supreme Court, like what is your viewpoint and why action should be taken or should not be taken against you. It ensures public authority respects the public rights of the individual. Against whom it can be issued? It can be issued against government and public authority, but you cannot issue a mandamus against president, governors, legislatures and individuals. Now let's talk about prohibition. Prohibition is nothing but restraint or injunction. Like, you compel a lower court to not proceed with a case which is beyond their jurisdiction or power. Again, principle of standus locus standi applies. It ensured that these courts that are the low that means the lower courts act within the confines of their jurisdiction conferred by the legislature, against whom it can't be issued. Obviously, if there's a judiciary with a higher bench, it won't be issued against them. Like, it cannot be issued against a high court or a supreme court. So surety, re-examination of order given by judicial, quasi-judicial or administrative authorities. Like, for example, if you approach a court and it gives an order, the Supreme Court will issue certiorari and will re-examine the order given by that court or judicial authority or quasi-judicial authority or tribunal, lower court, any other lower courts. They will examine their order, and if they feel that it's not valid or it's not a good order, then they will nullify it so that it does not decide the rights and liberties anymore. Let's talk about quo warranto. Quo warranto simply means that what is your authority, on what basis you can decide over that. Tell me what is your eligibility. It compels the person to disclose his or her eligibility of the post, and it can also remove the person if so it is required. Like, if the person is holding a post and he is not eligible for it, Supreme Court issues a quo warranto, ask him that show me your eligibility. If the person is able to prove his eligibility, he'll be continuing with the post. And if, for instance, the person is not able to show his eligibility, not able to prove his eligibility, he will be removed from the post. This writ can be issued even if no fundamental rights have been violated. Supreme Court on suo motu can issue this writ. Now, what are some facts that you should know? It is not only the Supreme Court that can issue writs, but also high courts can issue writs. The very same writs, all the 5 writs, even High Court can issue under Article 226. Now, this article, that is Article 32, gets suspended in the case of emergency. Thank you so much. I hope this was knowledgeable or beneficial for you all. Thank you.